HIPAA and Confidentiality. The goal of this training guide is to give basic information about patient confidentiality and privacy. It is one of the requirements of the Health Insurance Portability and Accountability Act of 1996 that all employees covered by the Act have to be trained in privacy matters and that training has to be documented. This training provides an overview of the rules of HIPAA and confidentiality. The Health Insurance Portability and Accountability Act, HIPAA, privacy, security, and breach notification rules protect the privacy and security of health information and provide individuals with certain rights to their health information. This publication discusses the privacy rule, which sets national standards for when protected health information may be used and disclosed, the security rule, which specifies safeguards that covered entities and their business associates must implement to protect the confidentiality, integrity, and availability of electronic protected health information, and the breach notification rule, which requires covered entities to notify affected individuals, U.S. Department of Health and Human Services, and in some cases, the media, of a breach of unsecured PHI. You play a vital role in protecting the privacy and security of patient information. This publication gives an overview of the rules, and it outlines the information protected by and who must comply with those rules. HIPAA Privacy Rule. The HIPAA Privacy Rule establishes a standard for the protection of PHI held by health plans, or we would call those ISP or IHP, the Individual Support Plan, the healthcare clearinghouses, those healthcare providers that conduct certain healthcare transactions electronically, and their business associates. The Privacy Rule gives patients important rights with respect to their health information, including rights to examine and obtain a copy of their health records in the form and manner they request and to ask for corrections to their information. Also, the Privacy Rule permits the use and disclosure of health information needed for patient care and other important purposes. Examples of PHI you may come into contact with would be the support plan, the MAR medication record, historical or other medical information including lab reports, doctor's appointments, etc. This is not an exhaustive list. If it is information related to the supported individual, it is probably PHI. When in doubt, ask your director. Protected health information. The Privacy Rule protects individually identifiable health information called PHI, held or transmitted by a covered entity or its business associate in any form, whether electronic, paper, or verbal. PHI includes information that relates to all the following: the individual's past, present, or future physical or mental health or condition, the provision of health care to the individual, the past, present, or future payment for the provision of health care to the individual. PHI includes many common identifiers such as name, address, birth date, and social security number. Realize any information which makes the person identifiable in connection with PHI may be considered a breach of privacy if it is disclosed. Having a conversation about a supported individual in a public setting, even using initials of the individual, is risky activity. Living in a small community, it is quite possible an individual can be identifiable by the things you say, even without the use of their full name, birth date, or social. The HIPAA security rules specify safeguards that covered entities and their business associates must implement to protect the confidentiality, integrity, and availability of ePHI, or electronic protected health information. Covered entities and business associates must develop and implement policies and procedures to protect the security of ePHI they create, receive, maintain, or transmit. Each entity must analyze the risk to ePHI in its environment and create solutions appropriate for its own situation. What is reasonable and appropriate depends on the nature of the entity's business, as well as its size, complexity, and resources. Specifically covered entities must. Application of HIPAA and confidentiality. Staff should not refuse access to a person's records unless specific court-ordered or rights restrictions are in place to do so. Staff should not leave PHI unattended. Staff should not include the documentation of one individual in the record of another individual. Staff should not discuss PHI in settings which do not protect PHI. Staff should share information only on a need-to-know basis. The need-to-know guideline protects situations which may be considered gossip. Telling someone else in the agency about an event simply because it was a big event is not acceptable. Sharing that information at shift change to prepare an oncoming staff is acceptable. This information may be shared from department to department inside the agency when necessary for the person's support. Further, ensure the confidentiality, integrity, and availability of all EPHI they create, receive, maintain, or transmit. Identify and protect against reasonably anticipated threats to the security or integrity of the PHI. Protect against reasonably anticipated impermissible uses or disclosures, and ensure compliance by the workforce. Texting is not a protected form of electronic distribution of PHI. If texting is necessary, you would either need to make sure that the person is not identifiable to someone who may receive the text accidentally, or not include protected health information in the text itself. Confidentiality. Electronic Protected Health Information, or EPHI, is not available or disclosed to unauthorized people. Integrity. EPHI is not altered or destroyed in an unauthorized manner. Availability. EPHI is accessible and usable on demand by an authorized person. Let's look at some examples. A staff member is purging the individual's historical record, but instead of shredding, the staff member throws the documentation into the trash. Or a staff person hears that he or she may be terminated. In an angry response, he or she destroys documentation and records of the individuals they have supported. Both of these scenarios would be serious breaches of HIPAA and confidentiality rules. What are the responsibilities of the provider? The security rule does not dictate security measures, but rather requires covered entities to consider all the following: size, complexity, and capabilities, technical hardware and software infrastructure, the cost of security measures, the likelihood and possible impact of risks to EPHI. Covered entities must review and modify security measures to continue protecting EPHI in a changing environment. These are the responsibility of the agency. If you feel there is a need for improvement in the policies and practices of the agency, you should contact your administrator. If you feel a breach has occurred, you are required by law to notify your administrator so a breach notification can be carried out. Let's look at the HIPAA breach notification rule. The HIPAA breach notification rule requires covered entities to notify affected individuals, HHS, and in some cases the media of a breach of unsecured PHI. Most notifications must be provided without unreasonable delay and no later than 60 days following the discovery of a breach. Notification of smaller breaches affecting fewer than 500 individuals may be submitted to HHS annually. The breach notification rule also requires business associates of covered entities to notify the covered entity of breaches at or by the business associate. You are protected. WCHS may not intimidate, threaten, coerce, discriminate against, or take other retaliatory action against individuals for exercising their rights or filing a complaint, individuals and others for filing a complaint with the Secretary, testifying, assisting, or participating in an investigation, compliance review, proceeding, or hearing, or good faith opposition to a prohibited act or practice. Who must comply with HIPAA rules? Covered entities and business associates, as applicable, must follow HIPAA rules. If an entity does not meet the definition of a covered entity or business associate, it does not have to comply with the HIPAA rules. With that said, it should be very clear that WCHS and all its employees are considered covered entities in relation to the PHI of individuals receiving supports. So what about times when you don't have a written release? Are there ever opportunities for sharing that information? A verbal disclosure of information is permissible when the supported individual is present and alert. If that supported individual is their own person and they decide to give someone verbal permission to share that information, then it may be shared. However, it's somewhat risky. If that person forgets or changes their mind and later says they didn't give you that permission, then you could have a significant problem. If the supported individual or patient is incapable to make wishes known, maybe they're unconscious, so this is what we call inferred permission, and it's only extended as far as discussing their current care in a way that is necessary for their care. If it's needed for care or payment, information needed for the patient's care for their safety and well-being with doctors, medical staff, or family members and friends who are clearly involved in the payment for care, and that involvement is obvious because the patient or the supported individual has said so. You may notify family or friends who are involved in the patient's care. Remember, they must be actively involved in that patient's care and that person's circle of care. with these following things: the patient's general condition, the patient's location, the patient being ready for discharge, or the patient's death. The patient's general condition given to someone who is involved actively in their care would be limited to very little information. You would not be able to release specific information about their condition without a release. The best practice in this situation is to refer the person who is inquiring about the condition to the administrator of your agency. Permitted disclosure with legal guardian. An individual calls to discuss the appointment information with you for a patient or supported individual and states he is the patient's legal guardian. May I discuss with the individual? Yes, after obtaining the court documents appointing the individual as the patient's legal guardian. You must make a copy of the court documents for the patient's file or confirm that it's there. You must confirm that the information being provided is appropriate and necessary. And if you're unable to obtain court documents verifying legal guardianship, do not discuss PHI with the individual. Guardianship paperwork is part of the individual's file. If in doubt, contact the director or assistant director to verify the person is the legal guardian. Otherwise, you'll need a written release to discuss the information. What about a step-parent or other relative? A step-parent calls to discuss her stepchild's care. May you discuss this with her? No, unless the step-parent is a legal guardian and WCHS has the guardianship papers on file or a legal guardian has provided authorization. Step-parents may call to schedule appointments but do not have access to their stepchildren's PHI without authorization by a legal guardian. So let's talk about enforcement. The HHS Office for Civil Rights enforces the HIPAA privacy, security, and breach notification rules. Violations may result in civil monetary penalties. In some cases, criminal penalties enforced by the U.S. Department of Justice may apply. Common non-compliance issues include impermissible PHI uses and disclosures, a lack of PHI safeguards, a lack of patients' access to their PHI, use or disclosure of more than the minimum necessary PHI, and lack of administrative ePHI safeguards. Let's look at an example of a settlement. Two covered entities inadvertently posted ePHI for 6,800 individuals on the web, including patient status, vital signs, medications, and laboratory results. The investigation found that neither entity made efforts to assure the security of the server hosting the ePHI or confirm it contained adequate software protections. Neither entity developed an adequate risk management plan that addressed potential threats and hazards to the ePHI. The entities agreed to pay a combined settlement of $4.8 million and enter into corrective plan of action. Let's look at another example of enforcement. It involved a criminal prosecution. A former hospital employee pleaded guilty to criminal HIPAA charges after obtaining PHI with the intent to use it for personal gain. He faced up to 10 years in prison. So why should you comply with HIPAA and confidentiality rules? To show your commitment to protecting the privacy of the individuals you support. As an employee, you are obligated to comply with WCHS, the Pam Dudley Center privacy and security policies and procedures. The individuals we support are placing their trust in us to preserve the privacy of their most sensitive and personal information. Compliance is not an option, it is required. If you choose not to follow the rules, you could be put at risk, including personal penalties and sanctions, and you could put WCHS at risk, including financial and reputational harm.